Amendment Fetal Abnormalities No. 2 Bill 2013, second stage. I am calling on Deputy Claire Dail to move the second reading motion that the bill be now read a second time.
Thanks, Count Corl. I would like to move the bill. And I do so on behalf of my colleague, Deputy Mick Wallace, on behalf of the wonderful parents and organisers of the terminations for medical reasons, some of whom are in the gallery with us tonight, who over the past period have waived their privacy to share their pain for no gain for themselves, but solely to make the world, I suppose, a better place and to stop other people suffering in the way that they had to. And of course I would like to recognise the legal input from Jennifer Schwepp, Dr Ruth Fletcher and Dr Emer Spain, whose time and expertise in devising this bill again was given gratis and for no reason other than to advance the public interest. And I'd like to start, Minister, by sharing an email that I received from a concerned grandmother. And this woman said, "Claire, I'm in tears typing this as I've just got off the phone from speaking with my son, who returned from Liverpool an hour ago. His beautiful wife having had a termination due to a fatal fetal abnormality. His wife was 6 months pregnant and could go on no longer waiting for their baby to die in the womb. What kind of country are we living in that we expect our young people to suffer like this? My son and daughter-in-law are two wonderful people, and to see them suffer because of our dreadful laws is appalling. It's hard enough for them to go through this ordeal, but to have to leave their country for a termination is truly awful. They are devastated. Please, for them and people like them, the law must be changed." Now, that email was sent to me, Minister, on the 11th of February last year. The journey made by the young couple on February the 10th, the day you and 103 other deputies in this House voted down this bill last time round. And I'm making that point not to embarrass you or as a cheap political point, but to register that we have to realise that decisions that we make in here or don't make have consequences. And without any shadow of a doubt, because you chose to do nothing, another couple are going to be going through this today. There'll be another tomorrow, there'll be one next week, and it will go on until we decide to act. The Master of the Rotunda, one maternity hospital, says 71 cases of fetal abnormality diagnosis last year. 49 of those couples decided to travel. That's almost one a week. Holles Street say it's about 2 people a week that they see that get this diagnosis. And we know that the Liverpool Women's Hospital said 2 to 4 Irish women are seen every week in their hospitals. So in other words, our failure to act last year meant that 200 women, their partners and their families endured what the human rights have said is a violation, mental and physical suffering, and hundreds more will experience the same next year unless we deal with it. Now, when I moved the bill last year, I quoted from one of the organisers of terminations for medical reasons, and she made the point, stop making excuses while women in this situation continue to contact us week after week, unsure of where to go or who to turn to, in shock at the extent to which they've been abandoned and stigmatised in the wake of Irish Government's continued excuse-making. They were the words of Amanda Mellett. Now, earlier this month, the expert panel of the United Nations Human Rights Commission found Ireland, in the case that Amanda Mellett took, to have violated that woman's human rights, to be free from cruel, inhuman and degrading treatment. We breached her right to privacy, we didn't protect her right to be free from discrimination, and we caused her immense physical and mental suffering. Not only that, but they obliged Ireland to provide her with an effective remedy, including compensation and psychological treatment, and obliged us to prevent similar violations from occurring by amending our law and, if necessary, our constitution. There's no opt-out from this. We have until the 7th of December to respond to this in detail. And contrary to what the Taoiseach has said, this judgment is binding. We voluntarily signed up to the International Covenant on Civil and Political Rights. We agreed to be bound by it, to accept its interpretation of the Covenant. There is no place for us to hide on this. You know, I've heard a lot of talk in the last few days about the Constitution and the Constitution being breached. But what about the violation of our international human rights being breached? There hasn't been any substantial talk about that, and it is a fact that the Constitution and domestic law can never be an excuse to violate human rights. Now, in the last Dáil, 50 deputies wrung their hands and said something must be done. Again, we posed the question 16 months ago, what have you done? And 16 months later, there hasn't been a single measure introduced in order to deal with these issues. Not only did we have the expert panel judgment earlier this year, but nothing happened on foot of the fact that 18 of our peer countries in the periodic review earlier this year again said we were violating human rights. The 7th international hearing where Ireland has been called to amend its legislation, and we have done nothing. Now, I've no doubt, Minister, that you're going to tell us about the Citizens' Assembly, where people can sit around and talk for 12 months, we hear, about these issues. That's going to be followed by an Oireachtas committee, where maybe they'll talk for another 12 months. And the reality of what you're putting forward is that it will be at least 2018 before any referendum would be put in front of the Irish people. That's not to mind all the delays that happened with the Constitutional Convention and anything like that. So that's the perspective that opens up if our bill isn't dealt with here tonight. And we're not saying it's perfect, but it can be amended, and we need to do something, because what you've put in its place is actually nothing. And I would remind you of the judgment in the Northern Ireland courts, where actually, on foot of an action taken by the Northern Ireland Human Rights and Equality Commission against the Minister for Justice, the courts there made it quite clear that it wasn't open for the Minister there to avoid his obligations under human rights, and it's not open to us here either. Now, this bill is incredibly restrictive. And just for the record of the anti-abortion lobby, it's not a backdoor attempt to get access to abortion in all circumstances. We're very prepared to go through the front door to demand access to abortion in all circumstances, but that is not what today's discussion is about. I think it's ironic when we did move a repeal of the 8th Amendment, people voted it down, and now that very voting it down is being used as a reason not to do anything on something today, and I don't think that that's actually good enough. What our bill deals with is the real and tragic cases where people get the devastating news, usually well into the pregnancy, that the fetus has a medical condition which is incompatible with life outside the womb. Now, this is a medical diagnosis. It's not a legal opinion. It's not a disability. It is something that the medical profession sadly have to deal with on a weekly basis. And at the moment, the only choices, it's a bad word, but that people have is to continue the pregnancy until they miscarry or the fetus dies, or they have to travel. Although, of course, we know that in many instances people can't afford to travel. In some instances it can cost a minimum of $3,000 up to $5,000. I know of people who got a diagnosis at 20 weeks, who couldn't afford to travel, who spent 17 weeks at home waiting until the fetus died. And, of course, it goes without saying that for those people who decide to continue on with the pregnancy and wait, they are unaffected by this bill. This bill deals with the people who can't continue and who decide that they have to, for their own mental health and well-being, as it were, turn off the life support machine. And what our bill says that if two medical practitioners, obstetricians and a perinatologist agree, then they are entitled to get a termination here at home in Ireland. It's something that's been sought by the masters of the maternity hospitals for more than 2 decades now, to continue the proper treatment for women in this situation. There is no happy ending from this situation, but we can actually make it a little bit sad, a little bit less sad. We can ensure that at a time when people are at their lowest ebb, when they need help the most, that we step up and provide that help. And against that backdrop, I find it utterly sickening at the excuses that we've heard as to why the government might oppose this bill. And if you follow through on it, and we'll deal with it in the sum up, that is a real insult, because if you really believed that the Constitution was a barrier to dealing with this issue, then you'd be coming in here today and you'd be putting on the agenda an immediate repeal of the 8th Amendment to ensure that human rights are not being violated. You would be ensuring that the other rights in the Constitution, right, Article 43.1, where the personal rights of the citizen are being violated because of our lack of abortion provision, but you've no measures put forward to deal with that. Instead, we're told, well, the Attorney-General says it's unconstitutional. Now, I have to say that is a pathetic cop-out. It's an excuse for inaction. As you know, we wrote to you, Minister, asking for you to publish that opinion so that it can be assessed and considered. At the very least, that's a minimum, because there were 43 other legal people who published a letter last time round which had a different opinion to this Attorney-General. And I note your response, which you sent us this afternoon, where you said that her advice is in line with legal advice received on the issue of fatal fetal abnormalities at the time of the Protection of Life During Pregnancy Bill. Now, that's interesting, because that confirms to us that that advice wasn't sought in relation to this bill last time round, nor this time around, and it certainly would be saying that it wasn't sought in the context of the violations of international human rights. But again, we have to return to the simple legal fact that Attorney-Generals can get it wrong. This Attorney-General certainly has got it wrong quite a few times. Other Attorney-Generals have had a different view on this issue. Other Attorney-Generals got it wrong before. They got it wrong in the X case. And the truth of the matter is, whether it's constitutional or not can only be decided by the courts. It's as simple as that. This is not repugnant to the Constitution. It's not, in a sense, clearly contradictory. At the very minimum, there is at least an arguable case that it could be possible for somebody in the circumstances of being diagnosed a fatal fetal abnormality to get a termination in Ireland. How do I know that? Because that's exactly the position that the Irish state argued 10 years ago this week in front of the European Court of Human Rights. And sadly, the European Court of Human Rights agreed with them, because they said that the state had put forward a tenable argument which could have been seriously considered by the domestic courts, that a fetus wasn't an unborn for the purpose of the article, and even if it was, its right to life wasn't going to be engaged, and therefore it did not benefit from the protection of Article 43.3. They talked about that the courts wouldn't operate with remorseless logic. They said that the woman in the case in question, that her case wasn't admissible because Ireland had shown that the remedy was possible in the domestic courts, that she had a reasonable prospect of success against our courts. But of course our courts never ended up testing this matter, and do you know what? They never will. Because how in God's name could we expect somebody whose world, the bottom has fallen out of their world, with a diagnosis of a fatal fetal abnormality in the case of a much wanted pregnancy at their lowest ebb, and we expect them to go into the courts and argue for the right to have a termination at home when they've enough pressing things in their place? That is never going to happen. But it is also the case that our courts have never adjudicated on this, and the only way in which they will adjudicate on it is if we pass this bill and if we allow the President to refer it on to the Supreme Court for adjudication in that regard. It would be entirely appropriate. There are many different cases that the courts have looked at. The tragic PP versus HSE case, where they talked about no prospect of being born alive, things not being exercises in futility. They talk about the Constitution saying as far as is practicable, but you know, if it's not practical to vindicate a right to life, then you don't have a necessity to do so, and so on. It might sound a bit ironic to say this is actually a positive proposal. Now, it's hard to envisage something positive in the midst of terribly tragic circumstances, but in actual fact there is a genuine and a huge desire across Irish society to have this happen. Over 80% of people repeatedly saying that this should be done. And what I really want to put to you, what's the worst that's going to happen? What would be so wrong about doing this? If we're wrong, we'll only be in the same situation that we're in now, so what's the harm? But if we're right, we actually have the possibility of alleviating some of the pain of the people at the coalface of this devastating diagnosis. And the last point I'll make, Ceann Comhairle, 3 weeks ago Fianna Fáil had a bill in this House dealing with property rights. The government and the minister raised that it was unconstitutional. He even put down an amendment saying that it should be referred to the committee to be dealt with its constitutionality. He subsequently withdrew that and allowed that bill to go through. So it's okay to do it for property rights, but it's not okay to do it for women's rights. I find that absolutely nauseating. I can't believe that we would stand up in a parliament and allow that type of attitude to go unchallenged. We can't prevail over these double standards. There's nowhere to hide, Minister. It's fallen on your lap. We can do a good thing today by passing this bill and signalling to people at last we're taking it seriously.
Thank you very much. Deputy Minister Simon Harris. Mr. Harris.
Ceann Comhairle, I want to thank Deputy Dail and Deputy Wallace and assure you I'm not looking for anywhere to hide on this issue. Ceann Comhairle, there can hardly be a more difficult situation for a woman who is pregnant to face than to be told by her doctor that her unborn child is not fully healthy and well, is not going to grow to achieve all that every mother and father wishes for their child, and worst of all, is not going to survive. All her aspirations and dreams for her child are taken away and are replaced with grief and distress at the very time when she should be facing a future of joy, of happiness and of hope. What unites this House is the empathy and the sympathy that we all feel for the couples and families who face these terrible situations. Indeed, this House has heard heart-rending personal stories from members who have had direct experiences of fetal abnormalities. I too have met families who have been through the trauma of knowing their baby will not survive and who have had the courage and the fortitude to share their stories in the hope of saving other people some of the pain they themselves endured. Only the heartless could fail to be moved. Life naturally, Ceann Comhairle, brings with its sorrows as well as joy, but there are certain tragedies that make us all feel the same sense of wrongness. The harsh realities of such a situation were made clear for all to see in the recent report from the United Nations Human Rights Committee, when it published its views on the complaint against the state brought by Miss Amanda Mellett, whose unborn child had Edwards syndrome. As I made clear at the time, I read the details in the report of Miss Mellett's experience with a heavy heart. Putting aside for a moment the wider constitutional issues involved here, the absence of compassion in her treatment by our health service was deeply distressing, and I am very sorry that this is how she was treated. And tonight I want to put on the record of this House my sorrow and my apology to Miss Mellett. Ireland's history shows that it has been in the past a cold and uncaring place for women and children, and I felt the echoes of that when I read that UN view. I will return to aspects of Miss Mellett's case again later in this speech, but I want now to address the bill before us. I know, I have no doubt, that Deputy Dail and Deputy Wallace and others who support this bill are minded by a deep personal desire to help every bit as much as anyone else in the House. I not only respect their views, but I share them. We all want to help. I'm in that 80% that Deputy Dail refers to. But we do want to do something in particular, do something meaningful to help. And I know that the deputies too would want their bill not only to be legal and constitutional, but also to have a meaningful impact, a real impact for women. Anything less would be to give false hope, to pretend we've done something for women who carry these babies, and indeed for doctors who care for them. Let me be clear. I am not opposed to the purpose behind this bill, and I will set out here in details the grounds on which it's currently not possible to support. In doing so, I am reflecting fully the legal advice available to me in relation to the constitutional issues pertaining to this bill, as per Deputy Dail and Deputy Wallace's request, as well as the medical advice that I have received from the Chief Medical Officer for the information of the House. Deputy Wallace and Deputy Daly's bill provides for termination of pregnancy following a diagnosis of fetal abnormality, which is defined in the bill as a medical condition suffered by the fetus such that it is incompatible with life outside the womb. The provisions for certification following receipt of such a diagnosis broadly mirror those of Section 7 of the Protection of Life During Pregnancy Act 2013. The two medical specialists required to certify under this amendment would be an obstetrician and a perinatologist. This country and this House is bound by the Constitution, one which can be frustrating at times. A referendum was held in 1983, resulting in the adoption of a provision which became Article 43(3) of the Irish Constitution, commonly known as the Eighth Amendment. As members will be aware, 43(3) reads as follows: "The State acknowledges the right to life of the unborn, and with due regard to the equal right to life of the mother, guarantees by its laws to respect as far as practicable by its laws to defend and vindicate that right." This bill before the House falls outside the parameters of Article 43(3) as interpreted by the Supreme Court of Ireland in Attorney General v X in 1992, also known as the X case, which held that if it were established as a matter of probability that there is a real and substantial risk to the life as distinct to the health of the mother, and that this real and substantial risk could only be averted by the termination of her pregnancy, such a termination was lawful. The Protection of Life During Pregnancy Act was commenced on the 1st of January 2014. And I believe that Act, by the way, addressed generations of neglect in this House in terms of facing up to a Supreme Court reality. Its main purpose is to regulate access to lawful termination of pregnancy in accordance with the X case and the judgment of the European Court of Human Rights in the A, B and C versus Ireland case. That bill was considered and debated extensively in Oireachtas committees, in this House, in the Upper House, and probably in homes right across this country. And I think it was well understood and acknowledged in the context of that debate that this piece of legislation was as far as the legislature could go in the absence of a referendum. I'm sure the House will also be aware that the second annual report on the Act has recently been laid before this House. Returning to the bill before us, the Supreme Court reviewed the meaning of the term unborn in Article 43(3) of the Constitution in Roach v Roach, in that case in 2010. On that occasion, Judge Denham, now the Chief Justice, stated with regard to the wording of the Eighth Amendment that both language versions refer to birth or being born. Thus, the fact of being born or birth is a factor in both versions. The beginning of life is not the protected term, it is the unborn, the life capable of being born, which is protected. The capacity to be born or birth defines the rights protected. Therefore, in the case of a fetus with a condition that is incompatible with life, but which is capable of being born alive and survive even for a very, very short period of time, such a fetus is protected by Article 43(3) of the Constitution. Deputy Wallace and Deputy Daly's bill does not define what is meant by incompatible with life outside the womb, but from examining the bill before us, two possible interpretations do appear possible. The first interpretation is that the unborn has a condition which is incompatible with life outside the womb, but which is capable of being born alive. It is clear that an unborn child who has the capacity to be born alive for a period, no matter how short, is protected by Article 43(3). The second interpretation is that the unborn has a condition which is incompatible with life outside the womb and has no capacity or capability of being born alive. And this is where I move from the legal advice to the medical advice, because I am informed by the Chief Medical Officer that the circumstances in which such a situation would arise do not exist in medical practice. It can never be said that a fetus with a fatal fetal abnormality will not be born to live for a short time, even if it is only to be minutes, to draw a breath, and to have a detectable heartbeat. If a fetus has the capacity to be born, it has the protection of our Constitution. Any bill that provides for termination in these circumstances, as this bill before the House does, would not be constitutional and would also not be medically practicable. Therefore, to introduce the well-intentioned provisions of Deputy Daly and Deputy Wallace, that would require a referendum to amend our Constitution. It is for this reason that I believe that the Government's commitment to develop a consensus approach within a Citizens' Assembly is the way to move forward. The Government has decided, in view of the Programme for Partnership Government commitment, to establish a Citizens' Assembly as quickly as possible, to make recommendations to this Dáil on further constitutional changes, including on the 8th Amendment of the Constitution, as their first topic. And let me be clear that Citizens' Assembly can report topic by topic, so there's no need for a Citizens' Assembly to wait till the end to report on each topic. The first topic it will consider will be the 8th Amendment. The issue of fatal fetal abnormalities can, and in my view should, be examined as part of this process, and the Assembly will also have the support of an expert group to provide it with the necessary legal and medical opinions. I have also said very clearly that I would absolutely expect that the views of the UN Human Rights Committee will be considered in that context. The Government is very conscious that the lack of access in this country to termination of pregnancy in cases of fatal fetal abnormality is one that has caused significant distress to many families. I have heard from the Terminations for Medical Reasons group on this issue, and I know some of them are here with us this evening, and I look forward to meeting with them in the coming days. I would like to take a moment to return to the Miss Mellett case. I have, of course, been informed by the HSE of the supports available to women who find themselves in very distressing situations. These include HSE funding for the provision of crisis pregnancy and post-abortion counselling, and in many cases medical examination through the Sexual Health and Crisis Pregnancy Agency programme. The woman's partner and/or family members can also attend these services for support. Approximately 3,000 women attend our state-funded crisis pregnancy counselling services each year. In 2015, over $3.3 million was provided to 16 state-funded crisis pregnancy counselling services through this programme. These services operate out of more than 40 locations nationwide. However, when I read the UN views in relation to Miss Mellett, not only was I struck in relation to the issue of terminations, which, whether we like or don't like the situation, is a constitutional reality currently, but what I was particularly struck by and upset by, and I think all our citizens were, was the way Miss Mellett was treated before and after by this country's health service. And that is what I've apologised for on the record of the House this evening. It is simply not good enough. The detail of the UN report shows that services that should have worked for Miss Mellett clearly did not. And there is no doubt that this added further to a very, very distressing situation. And Ceann Comhairle, I'm not satisfied to presume that Miss Mellett's is an isolated experience. That is why I have asked that the HSE report to me before my meeting with the TFMR group on the clinical and counselling services in place to support women and their families who have to deal with the prenatal diagnosis of a fatal fetal abnormality. I'm also considering, in line with requests I've received within the law, what other services and responses can be put in place to help women in these most terrible circumstances. In conclusion, Ceann Comhairle, I speak here today as a member of a generation who could not vote in 1983. In fact, I wasn't even born in 1983. My generation has never had our voice heard on this issue. Ireland has changed. Like many people, my own views on this subject have changed. The more I've considered this complex issue and the more I've listened to the real stories of people. When we listen to the stories of women who received the dreadful diagnosis of fatal fetal abnormalities in their babies, there is an absolutely inescapable truth. Our present law immeasurably adds to the pain of those who make the difficult decision to terminate the pregnancy. I really wish, and I really hope Deputy Wallace and Deputy Daly accept my bona fides in this, I really wish the case was that we could change that situation here today in the Dáil and on the floor of the Dáil. But being truthful, this House cannot change it alone. Only the Irish people can. And I hope, it is my absolute personal hope, that the Citizens' Assembly will recommend that those of us who were never asked the question, and indeed every other citizen in this country, will be given the opportunity to answer it after careful, considerate, respectful and informed debate. Ceann Comhairle, Deputies, it is for these reasons that I find myself in a position to oppose this bill, because, although absolutely well-intentioned, it is unconstitutional, and I cannot support this bill at this time, but I do hope that mechanisms are put in place to bring about the constitutional change that is clearly needed.
Mr. Regina Doherty.